warrant. But what about the new kinds of technology that more or less let the police look through your walls? The Supreme Court dealt with that in the case of Kylo versus the United States, where the police were using infrared technology that could see heat waves. They were looking for grow lamps that are typical of marijuana production facilities. And in this case, they found those kind of grow lamps using this infrared device, and based on seeing through the wall, went and got a search warrant, went inside the house after the warrant, and found a great deal of marijuana. The question before the Supreme Court was whether the use of the infrared technology constituted a search. Writing for the majority, Justice Scalia ruled that the information gained by using the infrared device could only normally be obtained by entering the house. When the police use devices to penetrate walls, they've conducted a search. The police needed a warrant before they could have used this device, and this would have required them to have probable cause before they used the device. It's very unlikely that the police had probable cause in this situation. A search occurs when the police invade an area where you have a reasonable expectation of privacy. But when are searches unreasonable? The Fourth Amendment does not prohibit all searches, just unreasonable ones. The most basic answer is that all searches of your home are presumptively unreasonable if the police do not first obtain a warrant from a neutral magistrate based on evidence that amounts to probable cause. Probable cause means that there's enough evidence to conclude that it's probable that two things are true. First, that wrongdoing has occurred, and second, that the person being searched is responsible for that wrongdoing. I use the phrase looking for evidence of wrongdoing rather than looking for evidence of a crime to emphasize the fact that the Fourth Amendment applies to civil cases as well as criminal cases. The child abuse cases that I've been involved in litigating Fourth Amendment issues are almost always civil cases. But the police or the social workers are still looking for some kind of evidence of wrongdoing. The police or other government officials can only get into your home either with a warrant or with two other exceptions. First, if you consent, the police can come into your home and there's no Fourth Amendment violation. The consent must be free and voluntary, but there's no rule that says the police must warn you that you have the right to refuse the entry. I've dealt with a great number of cases where the police and social workers are outside a person's house and there's a debate about whether or not they're going to get inside. And after determining that there's no warrant or other kind of a court order, I always tell people to not let the police inside. The reason is you would not believe the abuse that can take place inside your house once you let them in. One of the most common abuses is the social workers end up strip searching a child. Now, the motive of the social worker is always good, or almost always good. But the child doesn't understand that. All they know is they're in a room, mom and dad are being kept out, and a stranger's taken off their clothes. The effect on a child is very dramatic, and it's not unlike that of child abuse itself. They're trying to protect children from abuse, but they end up harming the psychological makeup of many kids by just doing this. But we've gotten into many situations where there's a debate after the fact of whether or not a person has let the police and social workers into their homes voluntarily, or whether their consent was coerced by some threat. If you ever find yourself in this situation and have the ability to tape record it, by all means, do so. Announce to the officers, I'm recording this entire event. But even if you can't record it, if the police are making threats against you, such as, I'm going to take your child if you don't let me in, let me describe what I usually tell my clients. Obviously, if you can get an attorney, do so in these circumstances. But here's a general description of what I tell people to do. Say to the social worker and the police officer, because you've threatened me, I'm going to get out of your way. You do not have my consent to enter. I'm going to close the front door to my house, but I'm not going to lock it. I will not resist your illegal activity if you enter my house. But I promise you that if you enter my house, I will file a federal civil rights lawsuit against you for violating my Fourth Amendment rights. Obviously, it's impossible for me to give you individual legal advice in a video series like this. Rather, this is just a description of what I normally do with my clients. If it is all possible for you to get a lawyer on the phone in these kind of circumstances, you should do so and listen to their advice. There's a second way that the police or social workers can lawfully enter your house. It's called the exigent circumstances exception. This means that the police can enter when there are certain kinds of emergencies. But there must be two things that are true for this exception to apply. First, there must be evidence of exigent circumstances. That is, some kind of an emergency that justifies immediate police action. Here are some examples. If the police are chasing a felony suspect who runs into a house, this is an exigent circumstance and they can follow him in. If the police receive a report that a dangerous condition exists in a house that requires urgent attention, such as a 911 call that reports there's a fire in the basement, that's an exigent circumstance. If social workers receive a report that a child is locked in a box and is being starved to death, that would be an exigent circumstance. There are many other fact patterns that would qualify, but these are fairly typical. But it's not enough for the police to have information that one of these kinds of emergencies are alleged to be true. There has to be evidence of the truth of the allegation, and the standard is probable cause. There's absolutely no doubt that the police have probable cause when they're chasing a fleeing felon and he runs into a house. They've seen him with their own eyes. They know what's going on. That's probable cause. But what about the anonymous hotline tip where it's alleged that the child's in a box and being starved to death? It's a very serious allegation. That part is satisfied. But what about the reliability of the evidence? A case that I litigated in the Ninth Circuit Court of Appeals answers the question on the reliability of evidence. It's called Calabretta versus Floyd. In this case, an anonymous tip was called into the child abuse hotline. No one left their name. There was no basis for concluding that the caller was reliable. There was serious doubt as to the emergency nature of the call, but for our purposes, let's just focus now on the issue of the reliability of the information. Based on a number of Supreme Court and other appellate decisions, the Ninth Circuit held that an anonymous tip standing alone could not constitute probable cause of an emergency. The rule is this: no matter how serious the allegation is, the police cannot enter your home using this exception unless the quality of the evidence amounts to probable cause. One of the reasons I really like Fourth Amendment law is because it is so close to original intent currently. There's one big rule and two historically grounded exceptions. The big rule is you can't go into people's house without a valid warrant. The exceptions are, did you consent, or was there valid evidence of an emergency? If you don't fit those historical patterns, that's the end of the equation. There's none of this common modern balancing test where you weigh how important is this compared to how important is that. Those tests are far away from original intent usually. And it is certainly not enough to get into your house based on the idea, we don't know what's going on in your house, therefore we've got to come in to investigate. That was the theory behind the writs of assistance in the 1760s. We don't know whether you have smuggled goods or not. And the founding fathers made it very clear, you can't come into somebody's house based on, we don't know what's going on inside. That's the very reason they fought for liberty, and that's the very reason we have the Fourth Amendment to the United States Constitution.